Rep. Ross asked Bondi if Maxwell deserves special treatment, then proved she already got it. The transfer happened in July. 2 days after Ghislaine Maxwell met with Todd Blanch, Pam Bondi's deputy and Donald Trump's former personal defense attorney, Maxwell was moved, not to a comparable facility, not to a security upgrade, from a federal correctional institution in Florida to a minimum security camp in Texas that, under the Bureau of Prisons' own classification standards, she was not eligible to enter. Convicted sex offenders do not qualify for minimum security placement. That is not a matter of discretion. It is a policy, and Maxwell is a convicted sex offender. Rep. Deborah Ross knew all of this when she took her seat at the committee dais. She had a timeline. She had the transfer documentation. She had the reports about what Maxwell had been receiving at the new facility, a facility whose informal name, Club Fed, is not the creation of critics, but a reflection of the reputation that low-security federal camps have among people who know the federal prison system. And she had something else. She had the survivors, the women who had survived what Maxwell helped run, who were in that hearing room, who would hear whatever Bondi said about whether a convicted sex offender deserves special treatment. Ross had organized her approach before her time began. The documents were in order in front of her, not stacked dramatically, not held up for emphasis yet, just there. The way a prosecutor arranges exhibits before a cross-examination, available when needed, not performed before necessary. When the chairman recognized her, she looked at Bondi across the committee room and began with what seemed like the most straightforward possible question. Ross started simply. She asked Bondi if she believed convicted sex offenders deserve special treatment or privileges in prison. Yes or no? Bondi said no. She said it clearly, not with visible discomfort, not with the hesitation that comes before a qualified answer. The answer was direct, and it was the right answer, and she knew Ross was building towards something with the question. The yes or no format was a tell. The question that has a yes or no answer, and that gets asked in that format in a congressional hearing, is almost always the predicate for the next question, which will be harder. Bondi answered it correctly and waited, and then Ross laid out what had already happened. This channel tracks the documentation as it moves through the legal system. If you want to follow where this goes, subscribe and turn on notifications. New videos drop when the record produces something worth documenting. Let's start with Todd Blanch, because Blanche is the character in this story whose role requires the most examination, and whose presence in the sequence of events raises the question that Ross was building toward from the moment she began her time. Todd Blanch is Pam Bondi's Deputy Attorney General. That is his current position. His prior position before joining the Trump administration was as Donald Trump's personal defense attorney, the lawyer who represented Trump in the criminal cases brought during the Biden administration. Blanch moved directly from defending Trump in federal court to serving as the second in command at the Department of Justice under an attorney general appointed by Trump. That transition from defense lawyer to deputy attorney general is not unprecedented in American legal history. Lawyers move between private practice and government service. But the specific configuration here is unusual. The lawyer who defended Trump against federal criminal charges became the second most powerful official in the federal law enforcement apparatus under Trump. And one of the first major things he did in that role was spend 2 days interviewing the woman who was Epstein's closest associate, whose testimony about Epstein's operation and the people connected to it could be the most consequential witness testimony in the ongoing accountability process. In July, Blanche spent 2 days interviewing Ghislaine Maxwell. The interview was at the Federal Correctional Institution in Florida, where Maxwell was serving her sentence. 2 days, not a brief check-in, not a routine case review. 2 days of direct, extended contact between the Deputy Attorney General, the man who had been Trump's defense lawyer, and the convicted co-conspirator of Jeffrey Epstein, who had been taking the Fifth Amendment in response to every question posed to her by other congressional committees. Days after that interview, Maxwell was transferred. The sequence is documented. The meeting happened. The transfer happened. The interval between them is documented. What was discussed in the meeting is not public. What decision, if any, was made during or as a result of the meeting is not public. But the sequence is in the record. Blanche met with Maxwell. Maxwell moved to a facility she was ineligible for. The meeting happened. The transfer happened. The interval between them is documented. The connection between them is the question. Ross put that sequence on the table and asked Bondi who ordered it. Bondi said she didn't know Maxwell had been transferred. She said she learned about it after the fact. She said the transfer decision was a question for the Bureau of Prisons. She said she was not involved at all. Not involved at all. That is the answer the hearing room was asked to accept. The Attorney General of the United States, whose deputy personally interviewed the most significant incarcerated cooperating witness in the most politically sensitive case the department is managing, was not involved at all in the decision to move that witness to a facility she was ineligible for days after the deputy's interview concluded. Let's hold that answer against the documented facts. The Bureau of Prisons operates under the supervision of the Department of Justice. The Attorney General is the head of the Department of Justice. The Bureau of Prisons does not make independent decisions about the placement of high-profile federal prisoners without the knowledge of the department's leadership, particularly not decisions that involve moving a prisoner to a classification level she is legally ineligible for. The transfer of Ghislaine Maxwell to a minimum security facility is not a routine administrative reassignment. It is a documented exception to an established classification standard. That exception requires authorization. It requires someone in a position of authority to have decided that the classification standard should be set aside in Maxwell's case. The Bureau of Prisons does not make that kind of exception autonomously. The Attorney General's statement that she was not involved at all is either a statement about her direct personal participation, which may be literally true if the decision flowed through Blanche's office without reaching her desk, or it is a statement about the institutional chain of command that does not fully account for how the Department of Justice's relationship to the Bureau of Prisons actually functions. Neither of those interpretations makes the not involved at all answer unproblematic. If Bondi genuinely did not know about the transfer, the question is why. The Deputy Attorney General conducted a 2-day interview with a high-profile federal prisoner, and that prisoner was subsequently transferred to a classification-ineligible facility. The Attorney General was not aware of either the transfer or the classification override. That gap in awareness is not exculpatory. It is its own kind of problem. Consider what awareness would require. The Deputy Attorney General returning from a 2-day interview with the federal government's most closely watched incarcerated prisoner would, in a normally functioning institution, provide some kind of summary to the Attorney General. Not necessarily a full briefing, not necessarily a written report, but some communication indicating that the interview occurred, what it covered, what the implications were for ongoing investigations or oversight matters, and what, if any, follow-on steps were being taken. If that communication occurred and did not mention the transfer, that is a gap in the communication. If that communication did not occur at all, that is a gap in institutional function. Either way, the Attorney General's not involved at all does not simply place the responsibility elsewhere. It raises a question about how information about a significant decision involving a high-profile prisoner in a politically sensitive case was managed or not managed within the department she leads. The Attorney General said she didn't know about the transfer. The transfer happened under her department. Those two facts are now in the same record. Then there were the reported privileges. Ross read them into the record. Puppy time, private workouts, personal mail, secretarial services. The informal name for the facility, Club Fed, is not hyperbole. It is a description. Minimum security federal camps are facilities where inmates experience significantly more freedom and comfort than in higher security institutions. They are designed for low-risk offenders. They are not designed for convicted sex traffickers who ran a multi-decade operation targeting minors. Maxwell, who was convicted of sex trafficking of minors and has been described by federal prosecutors as having played a central role in Epstein's operation, is now at a facility where puppy time is a reported feature of the inmate experience. The survivors sitting in that hearing room heard all of this. They had been in those seats before. They had come to prior hearings. They had submitted testimony. They had made public statements. They had fought for years through courts and congressional processes and media coverage to have what was done to them acknowledged and to see the people responsible face consequences proportional to what they had done. Maxwell's sentence, 20 years, was the most significant legal consequence produced by the Epstein investigation. It was not full accountability by the standards of most people who have followed the case, but it was something. It was a conviction. It was a sentence. It was the institutional acknowledgement that what was done to them was criminal, and that the person most responsible for the operational infrastructure of that criminality would spend years in federal custody. The transfer to Club Fed disrupted that acknowledgement, not legally. Maxwell's conviction stands, her sentence stands. But in the experiential language of what the government's actions communicate to people who have been harmed by the person those actions concern. When the Deputy Attorney General, who used to be Trump's defense lawyer, spends 2 days with Maxwell and Maxwell, is then moved to a facility she wasn't eligible for, with reported privileges that include puppy time and private workouts, the survivors reading those reports do not experience the sequence as an administrative matter. They experience it as a signal about how much Maxwell's comfort is worth to the people currently running the department that is supposed to be producing justice for what was done to them. Ross named it precisely. She said every time Maxwell receives perks and is publicly reported, the survivors feel re-traumatized. They feel denied justice. Bondi agreed that Maxwell should not receive special treatment. She said no, clearly and without qualification. When asked the yes or no question, that agreement was documented. It is in the record. It is the position of the Attorney General of the United States that a convicted sex offender does not deserve prison privileges. The transfer is also in the record. Bondi did not dispute this. She agreed that Maxwell should not receive special treatment. She said no, clearly and directly. When asked whether a convicted sex offender deserves prison privileges, what she did not do is explain how the situation that Ross was describing had come to exist. She said she learned about it after the fact. She said it was a question for the Bureau of Prisons. She said she was not involved. 3 responses, none of them an explanation. Now let's talk about the Fifth Amendment and the clemency offer. Maxwell was transferred. Maxwell received privileges. Maxwell took the Fifth in every hearing. And then Maxwell's lawyer made an offer. Maxwell, Ross noted, had taken the Fifth Amendment in response to every single question in a prior committee hearing. Not some questions, not the most sensitive questions. Every question. From the first to the last, Maxwell and her attorneys had invoked the constitutional protection against self-incrimination rather than provide any testimony at all. The Fifth Amendment is a constitutional right. Using it is not an admission of guilt, but using it in response to every question in a congressional hearing that is specifically examining the circumstances of the operation you were convicted of running is a statement about what testimony would reveal. Maxwell did not say she didn't know. She did not say the questions were improper. She declined to answer any of them. That total invocation is itself a kind of answer. It tells the committee that every question it might ask about the operation, about the participants, about the people whose names appear in the investigative records, about the relationships and events that the federal case documented, is a question whose honest answer would incriminate Maxwell or someone she is choosing to protect. A witness who takes the Fifth selectively is protecting specific information. A witness who takes the Fifth universally is protecting everything. Maxwell's universal invocation is a statement about the scope of what she knows. And then her attorney made an offer. The offer, as Ross described it, was that Maxwell would cooperate, would stop taking the Fifth, would provide testimony, would participate in the accountability process that her prior silence had completely shut down, in exchange for clemency from Donald Trump. Clemency is a presidential power. It is the power to reduce or eliminate a sentence. It is the power to commute a conviction. Maxwell was not asking Congress for anything. She was not offering cooperation to prosecutors in exchange for a plea agreement. She was offering her cooperation. The cooperation that the survivors and the committee and the public had been seeking in exchange for a presidential act that would reduce or eliminate the consequences she was serving for her crimes. And the man who met with her for 2 days before she was transferred to a facility she was ineligible for was the man who used to be Trump's personal defense attorney. Ross asked the question that this sequence made impossible to avoid. Should Donald Trump pardon or commute Maxwell's sentence? Bondi had already said she hoped Maxwell would die in prison. That statement, direct, unambiguous, delivered in response to the context of the discussion, was itself notable. The Attorney General of the United States, in a federal hearing room, expressed the hope that a specific federal prisoner would not survive her sentence. That is not standard official language. It is a personal statement of what outcome Bondi believed Maxwell deserved. Ross asked whether that meant the answer to the pardon question was no. Bondi said she had already answered it. That answer, I already answered that, is technically accurate. She had said she hoped Maxwell would die in prison. That is incompatible with supporting a pardon or commutation. But it is also not a direct answer to the specific question of whether she would advise Trump against a pardon, or whether she believed the clemency offer that Maxwell's attorney had dangled should be accepted. The distinction matters because the Attorney General's role in clemency is advisory. The President makes the final decision, but the Attorney General and the Department of Justice provide recommendations. The department has a formal pardon advisory process. If Maxwell's attorney is circulating a clemency offer, if the offer is moving through the channels that connect Maxwell's legal team to the people with influence over a presidential clemency decision, the Attorney General's position on that offer is directly relevant to whether it is received favorably. Bondi saying she hoped Maxwell would die in prison is a statement of personal desire. It is not the same as stating her official recommendation on the clemency request that her deputy's former client's former lawyer may eventually formalize. Trump's former defense lawyer met with Maxwell for 2 days. Maxwell was transferred. Maxwell offered to cooperate in exchange for Trump's clemency. Connect those dots yourself. The clemency offer is the detail that makes the entire sequence more consequential than any of its individual components. On its own, a prisoner transfer to a lower classification facility is a Bureau of Prisons administrative matter. Unusual, particularly given Maxwell's classification as a sex offender, but addressable through that institutional framework. On its own, reported privileges at a minimum security facility are a compliance and oversight issue for the Bureau of Prisons and the DOJ. On its own, a deputy attorney general interviewing a high-profile prisoner is a legitimate investigative function, however complicated by the deputy's prior relationship with the relevant political figures. Together, the interview by Trump's former lawyer, the transfer to an ineligible facility, the reported privileges, the Fifth Amendment in congressional hearings, the offer of cooperation in exchange for presidential clemency. They describe a specific shape. A shape that begins with a meeting and ends with an offer that can only be accepted by the president whose former lawyer conducted the meeting. That shape does not prove coordination. It does not prove that any of the individual elements were designed to produce the offer at the end. What it does is place the individual elements in a sequence that raises the question of whether they are connected, and if so, how. The question cannot be answered by the public record as it currently exists. What the public record contains is the sequence itself and the institutional actors at each point in it, and the question of connectivity that the sequence makes unavoidable. Ross asked who ordered the transfer, because the answer to that question is the answer to the connectivity question. If the transfer was authorized by someone who was in communication with Blanche about the outcome of his 2-day interview, the shape becomes something different from coincidence. If the transfer was authorized entirely independently by Bureau of Prisons officials acting on classification criteria that Ross described Maxwell as ineligible for, then the shape is a sequence of coincidences, and the connectivity question has a different answer. Either way, the answer is in the authorization document. And Bondi said she didn't know whose signature is on it. Ross asked who ordered the transfer. Bondi said she didn't know. That is the answer that is in the permanent record. Not who ordered it, not why, not whether the Bureau of Prisons acted independently or in response to communication from the department's leadership, not whether Blanche's 2-day interview was connected to the transfer decision or entirely unrelated to it. The Attorney General of the United States did not know. That is what is in the record, not who ordered it, not whether Blanche's interview was connected to the transfer decision. Not whether the Bureau of Prisons acted independently or in response to some communication from the department's leadership. Not whether the reported privileges were authorized by the facility's administration on their own initiative or in response to some signal about how Maxwell should be treated. Not whether the clemency offer that Maxwell's attorney circulated was discussed in any way during Blanche's 2-day interview. None of that is in the record. What is in the record is the sequence, the meeting, the transfer, the privileges, the Fifth Amendment, the clemency offer, and the Attorney General saying she didn't know. That last element, the not knowing, is the gap in the documentation that every subsequent proceeding will have to account for, because it is either accurate and represents an institutional failure of awareness at the highest level of the department, or it is not fully accurate and represents something else. Either way, it is now in the permanent record of a congressional hearing, sitting next to the documented sequence it was offered to explain. Here is what the documented sequence produces as a question that the record cannot yet answer. The Deputy Attorney General met with Maxwell for 2 days. Maxwell was transferred to a facility she was ineligible for. Maxwell received reported privileges she was not entitled to. Maxwell invoked the Fifth Amendment in every congressional hearing that asked her to testify. Maxwell's attorney offered cooperation in exchange for clemency from Trump. The Attorney General said she was not involved in the transfer and learned about it after the fact. The missing piece, the piece that the documentation does not yet contain, is the decision maker. Who authorized the transfer? Who signed off on the classification override? Who, if anyone in the department, communicated to the Bureau of Prisons that Maxwell should be moved? The Bureau of Prisons has a process for prisoner transfers. That process generates paperwork. There is an authorization form. There is a classification review. There is a record of who made the determination that the standard classification criteria should be set aside. That record exists. It has not been produced to Congress. Ross asked Bondi, who sent Maxwell to the minimum security facility. Bondi said she didn't know and directed the question to the Bureau of Prisons. The Bureau of Prisons operates under the Department of Justice. The transfer authorization is in a file. The file has a custodian. The custodian can be subpoenaed. And the question of who signed the authorization, the question whose answer Bondi said she didn't know, is a question that a subpoena would force into the public record. The survivors in that room had watched all of this unfold. They had watched Maxwell's 2-decade sentence begin in a federal correctional institution. They had watched her take the fifth in committee hearings. They had watched her attorney dangle cooperation in exchange for a pardon. They had watched the timeline, meeting, transfer privileges, become public record. And they were sitting in that hearing room when the Attorney General said she didn't know about the transfer, said it was a question for the Bureau of Prisons, said she hoped Maxwell would die in prison. The statement about dying in prison was directed at them. It was the statement Bondi could offer that was consistent with the position that Maxwell should receive no special treatment, the position she had confirmed with a yes or no answer before the details of the transfer had been laid out. The hope that Maxwell would die in prison was the strongest possible statement against clemency, against pardon, against any reduction of the consequences Maxwell was serving. But the transfer had already happened. The privileges had already been reported. The clemency offer was already on the table. And the Attorney General had learned about it after the fact. The hearing room has a specific acoustics to it when an official says they didn't know about something they should have known about. It is not the silence of acceptance. It is the silence of people processing whether the answer is an explanation or the beginning of a different set of questions, whether not knowing is the end of accountability or the location where accountability begins. Ross had spent her time building a documented sequence that made not knowing its own kind of answer. The sequence is in the record now. The transfer happened. The privileges are reported. The clemency offer is on the table. And somewhere in the Bureau of Prisons files, the authorization for Ghislaine Maxwell's transfer to a facility she was ineligible for has a signature on it. The Attorney General doesn't know whose.